Everyone. Welcome. Let's do roll call. Chair Wallen here, Vice Chair Duffrin.
Here.
Commissioner Grunwald.
Here.
Commissioner Oscarson.
Here.
Commissioner Sheets.
Present.
Commissioner Towler.
Here.
Commissioner Yin.
Present.
And Commissioner Lowry is excused absence today. For staff, Commission Counsel Chase.
Here.
Executive Director Armstrong.
Here.
Associate Counsel Bassett.
Here.
Senior Legal Researcher Hayden. No, okay, she's not with us, okay.
Here.
Oh, she is, okay. Executive Assistant Pedroza.
Here.
And Investigator Terry.
Here.
Right. All right, this time we will do the Pledge of Allegiance. I pledge allegiance
To the flag
of
of the United States of America
and to
And
the
to the
republic
republic for which it stands,
one
a
nation,
nation under God,
God,
indivisible,
indivisible,
with liberty and
liberty and justice for all.
Right, at this time, I would like to ask if there is any public comment, members of the public on Zoom. Executive
Yes, I have
Director
public
Armstrong.
comment.
All right, yes, please proceed and identify yourself.
Yes, for the record, good morning, Fred Volz, V as in Victor, OLTZ. The following comments pertain to your agenda item number 6. Speaking as a Boulder City resident and someone who actively engages in public policy discussions, the proposed resolution of this situation misses several pivotal points. First, Stephen Morris has been a Nevada licensed attorney for almost 22 years. He graduated from an ABA accredited law school where one of his first classes taken would have been legal ethics. To keep his active Nevada legal license status, he had to complete multiple continuing education classes over the decades, which would have serially reinforced what is and what is not ethical behavior. Second, Mr. Morris holds the position of stake president at his local religious affiliation. The person who filed the original open meeting law complaint, Peggy Levitt, is one of his subordinates within the same religious affiliation. Ms. Levitt is not an attorney, yet the complaint she filed with the state attorney general strongly suggests someone with legal training wrote it. Before rendering any decision, this commission would be well advised to interview both Ms. Levitt and Mr. Morris under oath to determine if there was any collusion between them in filing the frivolous open meeting law complaint. The complaint was ultimately determined by the state attorney general's office to be without legal foundation or merit. Third, seasoned lawyers such as Mr. Morris regularly operate with an abundance of caution and voluntarily recuse themselves from any situation where there might be even a scintilla of a conflict of interest. When Mr. Morris's employment contract and future income are prospectively at issue before a public body, an unassailable conflict of interest exists in any legal advice he might proffer to his client at the time, the city of Boulder City. Mr. Morris needed to engage other legal counsel to represent the city's best interests for this agenda item, but willfully chose not to do so. The proposed remedy, which is another ethics class and temporary monitoring of his behavior under unlimited circumstances, does not address the core problem of a demonstrated ethics breach. It seems a more appropriate remedy would be imposition of a substantial fine upon Mr. Morris personally by this commission, in addition to referring the matter to the Nevada State Bar for whatever disciplinary action they deem appropriate to protect the public and legal profession from the taint of poor legal practitioners. And I would ask that these comments be added verbatim to the meeting record. I will email them to your secretary, and I thank you for your attention.
Thank you very much, Mr. Volz. Anyone else wanting to make public comment that is on Zoom?
Yes, this is Kieran McManus, and I would like to make public comment.
Yes, please proceed, Mr. McManus.
Thank Madam Chair and Commissioners, I want to thank you for the opportunity to address you with regard to item number 6 on your agenda today. I ask my comments be included verbatim in the minutes of this meeting. This item is in regard to an ethics complaint filed against the actions of Stephen Morris when he was the city attorney of Boulder City. I am the current mayor of Boulder City and was a participant in filing this complaint. I do not believe this agreement should be approved by the commission as it contains significant factual errors. The agreement states that an agenda item that I had requested for a city council meeting was not clear and complete. Mr. Morris had attempted to remove the item from the agenda at the beginning of the meeting in his role as city attorney. The Attorney General reviewed the open meeting law complaint filed for that reason. The Attorney General issued an opinion stating the item was clear and complete, and the actions that I and others had taken did not violate the open meeting law. The agreement also states that Mr. Morris did not have a pecuniary interest in the agenda item. The agenda item was a request to consider retaining special counsel by the City Council to review the employment contract of Mr. Morris and other appointed officials. Mr. Morris should have recused himself from any involvement in the item as it was related to his employment contract. Mr. Morris continued to interfere and oppose having the City Council review his employment contract. Many of those actions were documented in the ethics complaint that is now being considered. Mr. Morris's actions were unethical and were intended to serve his interests. Again, I ask that this agreement not be approved and that the commission review the matter to determine the appropriate action with regard to Mr. Morris. Thank you.
Thank you, Mr. McManus, for your comments. Is there anyone else on Zoom wanting to make public comment? All right. Okay. Executive Director Armstrong, have we received any public comment via email?
Thank you, Chair. This is Executive Director Armstrong. We received written comments from Karen McManus, Judith Hoskins, Roger Tobler, Peggy Levitt, Lorene Crum, Lauren Oliver, and Steve Walton. All of those public comments are uploaded and part of the materials, and they all relate to agenda item number 6, and can be reviewed by the members of the commission.
Thank you. All right. Is there any other public comment? Right, then we will go ahead and close public comment at this time. First of my item on the agenda, item 3, approval of the January 19th, 2022 commission minutes. Commissioner Sheets was absent from the meeting, but all the other commissioners were present and may approve the minutes. Are there any additions or corrections to the minutes? No? Do I have a motion to approve the minutes as read?
This is Commissioner Yen.
Okay. Commissioner Teller made the motion and Commissioner Yin
I'll
second.
second.
Yeah, okay, great. All right, all those in favor say aye.
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 Opposed? Right? Motion carries. Next item, item 4, Executive Director Agency Status Report. I'd like to ask the Executive Director Armstrong for your presentation. Please proceed.
Thank you, Chair. This is Executive Director Armstrong. And in agenda item number 4, there's a written report that is in your materials. I'll briefly go over some of the highlights from that report. The first section of the report includes our education and outreach. We have been working on a focus on growing our audience in social media to get the word out about the commission. We've had 13% growth in Twitter followers since the first of the year, and we've doubled those folks following the commission on LinkedIn. I think what we're seeing is Twitter is a good opportunity to reach out and educate the public and members of the media and government about what is going on in the commission, where LinkedIn seems to be more focused. A lot of our followers are public officials and employees. So LinkedIn, I think, is going to be a great vehicle for education and outreach going forward to the folks who are actually bound by the ethics law. We've also secured some trainings. We have a training in Boulder City and in Nye County scheduled for early April, and one for the Carson City executive team in early March. And so we are starting to see more and more requests for education and outreach, which is wonderful. In addition, since the last meeting, I participated as a panelist in the campaign for legal change. They had an ethics panel about their report on top 10 transparency items. And so I was one of 3 directors who participated as a panelist in that, which was a great opportunity to share the good work of the Nevada Commission on Ethics. Are there any questions about the education and outreach efforts or section of the report?
Fellow commissioners? No, but no, you're doing it. You're doing a great job. And like I said, my fellow commissioners, if you have a Twitter account, follow the Nevada Ethics Commission and help promote it.
The next items includes the budget and identify those budget categories where it looks like we have a surplus and those we may need to do a work program. In some additional meetings since the report was submitted, it looks like we had budgeted still for mail for 2 offices. We only have 1 office. So I actually think category 4, we will not have a need for a work program, but we continue to monitor that. There are really no concerns on my front in terms of budgetary issues. We have plans to spend down the money where we need to spend down money, and there's no area where we're looking at like a large shortfall. There may be some areas where we shift between categories, but we have plenty of funds in those categories to shift to the other categories, so the budget looks strong. Are there any questions about the budget?
I have a question. This is
Yes.
Vice Chair Dufferin. When you shift monies in the accounts, do you need any kind of special legislative approval to do that?
Yeah, there's this is Executive Director Armstrong. There's a work program process that can shift from one category to the other. If an entire agency does not have enough funds somewhere to shift around, then there's an ability to tap into the legislature's reserves. I foresee no need for doing that. So yeah, there is a process that we work through with our partners at the Administrative Services Division and then the Interim Finance Committee to do so.
Great, thank you.
Any other questions? Right? Continue.
Okay, and then I'll kind of lump the next 2 together and give a case status update. We are making good progress on the backlog. We have 3 substantial panels set for today. We are on track. I think by the end of the March meeting and panel process, I think we can officially declare that backlog cleared, and we'll provide that very specific case log document to show you where everything is. But we've made some good progress. Some of the items, of course, that were set in kind of that investigation area may now be set for adjudicatory hearings and negotiations and stipulations. So you'll see a shift in the workload from that investigation piece of the process to that next piece of the process as we head to disposition. But things are looking good in terms of the case status and clearing that backlog. And then the meetings we're set to meet on March 16th and April 20th. Those are our next 2 meetings. I think we're continuing to monitor the COVID situation, but I think be interested in the commission's thoughts. I think it would be good to have 1 meeting before the end of this fiscal year in Las Vegas, and hopefully the COVID situation allows us to do that. We do have the Gwynn Room pre-reserved for all of our meetings this year, and so if we adjust to an in-person meeting, then we have that as an option already on the books. So, and of course, there's an item later today about a legislative subcommittee, and we'll work on coordinating those meetings as well. So that's where we are in terms of the commission meeting status, and that concludes my executive director's report for this month.
Right. Fellow commissioners, any questions for Executive Director? It would be good to do an in-person meeting. We have not had an in-person meeting with the full commission since February of 2020. So we've got some new commissioners, so it'd be nice to do it. So hopefully the numbers will be down and it'll be safe for us to travel and get together. So, and I want to thank the staff for all their hard work in getting the backlog caught up. I mean, it seemed like we were never going to get caught up earlier in this year, and you've done a tremendous job getting it caught up. So thank you. Kudos to all of you for your hard work. All right, is there a motion to approve the Executive Director's agency status report as presented?
I'll make that motion, Madam Chair.
All right, is there a second?
I'll second.
All right, all those in favor say aye.
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 Aye. All right, motion, all opposed, right, motion carried. Right, next item, item 5, consideration and approval of the telecommuting policy as presented by the executive director. This item was continued from our January meeting so that the commission revisions could be included in this revised telecommuting policy. So you guys have all seen it. So are there any questions, comments after you've seen the revised policy, fellow commissioners?
Yeah, I just have a comment. I really, I met with Mr. Armstrong, Mrs. Chase, and they put a lot of work into it. I think it looks really good now, and I'm very pleased with it, and I appreciate the work they put into that. Just wanted to add that.
Thank you. Any others? Okay. I think that after reading the revised policy, it looks great. And I want to thank Commissioner Towler for also working with them and helping them with some of the key employment areas that we weren't aware of before our last meeting. So thank you for doing that. Right. If I don't hear any other comments or questions, then I will entertain a motion to approve the telecommuting policy as presented.
Commissioner Towler, I so move to approve.
All right. And is there a
Second, Madam Chair.
All right. All those in favor say aye.
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 Opposed? Motion carries. Thank you. Next item is item 6, discussion and approval of proposed stipulation for consent order concerning ethics complaint number 20-007C, Morris, former city attorney, City of Boulder City, Nevada. I would like to call the item and indicate for the record that the members of the review panel will not be participating on this item pursuant to NRS 281A.2204. The review panel members are Commissioners Grunwald, who is the presiding officer, Commissioner Dufferin, and Commissioner Yen. And you have put them in the timeout room, right? Executive Director Pedroza?
I will do that right now.
All right, thank you. Right, at this time, I would like to ask the attorneys and the parties to identify themselves for the record.
Elizabeth Bassett, Associate Counsel for the Executive Director.
Brian Hardy with the law firm of Marquis Arbach on behalf of the subject, Steve Morris.
Okay, thank you. And I see we have Mr. Morris present as well, so.
Yes, good morning.
Good morning, thank you. All right, at this time, I would like to have a presentation from our Associate Counsel Bassett.
Thank you, Madam Chair. For the record, I'm Elizabeth Bassett, Associate Counsel for the Commission. The proposed consent order before you today recommends the terms of a settlement in ethics complaint number 20-007C concerning Stephen Morris, former city attorney for the City of Boulder City. The complaint in this matter filed by the city's mayor and one of its city council members alleged that Mr. Morris violated NRS 281A 420 subsections 1 and 3. The form of the agreement between the form of the recommended agreement between the commission and Mr. Morris is a consent order. NRS 281A 135 and NRS 233B 121 allow the commission to resolve an ethics complaint by consent order. The documents and the interviews obtained during the course of the commission's investigation show that the mayor directed the city clerk to place an item on the city council agenda regarding, in part, the retention of a special counsel to review and advise on an open meeting law standards and requirements and employment contracts of certain municipal officers, including the city attorney. In his role as city attorney, Mr. Morris and the mayor engaged in several email exchanges in which Mr. Morris set forth various specific legal concerns regarding whether the agenda item met open meeting law requirements. The city had previously recently been the subject to an open meeting law violation. Mr. Morris did not disclose any pecuniary interest in his employment contract with the city in those emails. During the discussion of the agenda item at the city council meeting, the mayor stated that Mr. Morris had a conflict of interest and that it was inappropriate for him to continue to recommend removal of the agenda item. Mr. Morris stated that he had an ongoing obligation to protect the city council from possible open meeting law violations, that matters of public concern require a heightened obligation of a specificity, and that the agenda item failed to provide that required specificity. Mr. Morris did not disclose a pecuniary interest in the item or his employment contract as city attorney. The vote on the item ultimately failed to pass at the meeting. The review panel determined that just and sufficient cause existed for the commission to render an opinion regarding the alleged violations of NRS 281A 420 subsections 1 and 2, based on the complaint. Thereafter, the executive director and Mr. Morris engaged in additional discovery, and documents obtained by Mr. Morris in ongoing litigation between himself and the city of Boulder City were produced to the executive director. Those documents, which primarily consisted of emails between the mayor and third parties, showed that the mayor and other community members were specifically targeting Mr. Morris and working to create cause to have him removed from his position at the time of this agenda item. That included crafting the agenda item in a way that they believed Mr. Morris would have objections to, and then filing this complaint against Mr. Morris. Well, that does not excuse his failure to disclose his pecuniary interest or excuse the ethics violation. Those are in fact significant mitigating factors that support the agreement presented today, along with the additional mitigating factors, which are that Mr. Morris has not previously been the subject of any violation of the ethics law, that Mr. Morris is no longer a public officer or employee, that Mr. Morris was diligent to cooperate with and participate in the commission's investigation and resolution of this matter, that Mr. Morris did not receive any financial benefit as the result of his alleged conduct, that Mr. Morris repeatedly requested more information and specificity about the subject of the agenda item so that he could determine whether he needed to make a disclosure and what kind of disclosure he needed to make, which information the mayor refused to provide, all of which is documented in emails that we have and have reviewed. And that during the meeting, Mr. Morris as the city attorney never approved, disapproved, voted, abstained from voting, or otherwise acted upon the matter in which he had a significant pecuniary interest. Mr. Morris simply voiced his objection to the way the item had been identified on the agenda in an effort to protect the city of Boulder City from an open potential meeting law violation, which it had recently been found guilty by the AG's office of an open meeting law violation just prior to this agenda item. Mr. Morris currently has a civil action pending against the city of Boulder City and others based upon the conduct of the mayor and others. And that case is currently pending the 8th Judicial District Court. The consent order requires that if Mr. Morris accepts an appointment as a public officer or employee or employment representing a public body within 2 years from the date of the approval of this consent order, he must attend ethics training within 6 months and comply with the ethics law for 2 years without being the subject of another ethics complaint for which a review panel finds there is just and sufficient cause. Another requirement of the agreement is that Mr. Morris consents to the commission's issuance of a confidential letter of instruction advising him about the implications of the relevant ethics law. Although that letter of instruction is confidential pursuant to NRS 281A 780, the commission may consider it in deciding the appropriate action to be taken against Mr. Morris in any subsequent ethics complaints. And I'd also like to note that since in the time since we first negotiated this agreement, Mr. Morris's counsel and the executive director and I have agreed to change the language of the agreement a little bit, given sort of the concerns we saw in public comment, that instead of having language that says that about the clear and we're going to change the language a little bit, instead of saying that the language of the agenda item was clear and met the open meeting law standard, that instead just that Morris had difficulty in ascertaining whether the agenda item at issue created a conflict of interest or disclosure requirement for him. So hopefully that addresses some of the concerns that some of the public commenters had. That seemed to be something people had concern about. But given the information obtained in the investigation of this matter and the mitigating factors presented, the executive director and I believe the terms of the agreement presented today are appropriate. We would like to thank both Mr. Morris and his counsel, Mr. Hardy, for their cooperation and patience in the investigation and the resolution of this matter. I'm happy to answer any questions you may have about the proposed agreement.
Mr. Hardy, do you have any comments or additions to Associate Counsel Bassett's presentation?
First of all, Madam Chair, members of the commission, I want to thank your staff for the wonderful diligent effort that they always undertake in looking at these matters. And not only that, but the insights of the executive director and his diligence in pushing both this matter forward and some of the other matters that I have for other clients. He's doing a great job getting things caught up. So I really do appreciate that on behalf of myself and my clients. With respect to this particular matter, there's been a number of there's been quite a bit of discovery that's taken place over the last couple of years in this particular matter that has brought to some of the mitigating circumstances that you've heard about. The language proposal that is being discussed was the change was relative to section 4F, let's see, 4FD, if you will. And the language proposal there is the intended language was to identify the state of mind of Mr. Morris. It wasn't meant to make an assertion of law or make any comment on any other opinion that had happened. And in order to clarify that, to avoid some of the issues that had been raised in public comment last night by members of the public, we changed that language to say Morris had difficulty in ascertaining whether the agenda item at issue created a conflict of interest and or disclosure requirement, leaving out that language of clear and complete, which comes out of the language relative to open meeting law specificity. So this is about Mr. Morris. It's about what his thoughts were in his head as evidenced by the emails that were sent back and forth when he was requesting that additional information from the mayor. If there's any other questions you have, I'm happy to answer them. As always, we appreciate your consideration. Thank you.
Thank you. Right, I will open it up to my fellow commissioners for questions of the parties. Fellow commissioners, questions on any of these? Commissioner Sheets?
Okay.
Okay. Commissioner Towler?
No questions from me.
Commissioner Oscarson?
No questions for me, Madam Chair.
Yeah, I want to thank staff for their hard work on this and working with the parties, Mr. Hardy and Mr. Morris, for your cooperation. We appreciate it. I guess, we haven't had this much public comment on an ethics issue before, a case before us and stuff. And I don't know, and we weren't privy to all the negotiations. I know that this has been going on since, God, sometime in 2020 or something, I want to say. It's been a while. I don't know if you guys can shed any light on that, to how you came to this conclusion and how you feel it's in the best interest and addresses the issue, we had some pretty strong public comment this morning, okay? And then we also had some very strong public comment via email as on the other side of it and stuff. So can you address some of these issues that the people in public comment had and how this addresses this issue? Or
Well, so this is Associate Counsel Bassett. As you know, this actually substantially predates my time in this position. When I first came on, this had already gone through the review panel, had been referred to the commission, but was stayed because of the litigation between the city and Mr. Morris. And I'm sure Mr. Hardy can shed more light on that because he predates this with that more than my time. But apparently it was stayed by the previous executive director pending some of the discovery in that litigation and what it would show relative to the discovery in that, I believe it's a religious discrimination lawsuit, an employment lawsuit. And then that discovery did in fact come to us to shed light on what in fact did happen here. So I believe the purpose of staying it here was to see what would show up in that discovery and then what relevance that might have to whether this was in fact a violation or not. I think Mr. Hardy can speak to that.
Madam Chair, just to kind of give you some history on what happened here, as you know, this was stems out of a meeting that happened in 2019. The complaint was began right in the very beginning of 2020. We immediately and timely addressed the issue, and then sat down with the executive director at the time and looked at this. And that was after interviews had already been conducted by your staff of Mr. Morris and others. And after that had occurred, we looked at it and saw this existing litigation that was ongoing, and we decided, well, either one of two things could happen. Either we can all spend time and energy and money and go do the same discovery that's happening, or we can stay it, allow the discovery to happen in the underlying civil litigation, and then produce to the Ethics Commission all of the discovery, including depositions and whatnot, so just as a savings and an expense. So that way you didn't have to bear the burden of this. Obviously, there was no need for the Ethics Commission to undertake or be a participant in all of those depositions at its own cost and expense, or at any cost or expense. And so we simply stayed it for the period of time of discovery, brought all of that discovery into this case and supplemented it. So that way you have copies of any and all discovery that took place in the underlying one, and then reopened it. At that point in time, we submitted supplemental response letter that updated everything relative to the information that had been gleaned from discovery, which actually provided some pretty significant insights as to what had actually taken place here. And as kind of been described and as is set forth in some of the facts that you see inside of the proposal in front of you, is that there were actually quite a bit of correspondence between the mayor and the city attorney, where the city attorney had some serious concerns about having a repeat open meeting law violation. And this is something that and just for the record, it's OAG file number 13897-243 was the Attorney General's opinion that said that the City Council had violated open meeting laws. That had come out less than 18 months before before this incident. And so it was something that was in the attention of Mr. Morris. Not only was it in his attention, that was the same meeting where Mr. Morris was actually appointed as the city attorney. So it's fresh in his mind as well. And the fact that he was really aware of this and didn't want to make the same mistakes that had been made previous to him. And so he was very cognizant about making sure to protect the city. That's all he desired to do, was protect the city from any type of additional open meeting law complaint. And so in doing so, he reached out to the mayor and said, Mayor, I have some concerns over this particular item that you have here, that it may not be sufficiently clear. And the mayor, and can you provide some additional information? The mayor refused to do so. He then went back and said, will you please give me something here? Because I may have, and in fact, in his own words, he acknowledged he may have an issue or a conflict here, but he can't determine that based upon the description. Please provide me some additional information so I can decide whether I'm going to be able to make that determination. And the mayor refused. And the mayor pushed the item forward. And that's where we sit today, is that we had somebody who had this confusion. And so what he did at the meeting was he openly disclosed what he knew. I have concerns about the open meeting law, but that's all I'm going to deal with here, because I don't know what's going to happen beyond that. So you're going to have to go ahead and act on it. And ultimately, the city council didn't do anything with it. There was a motion, it didn't pass, and things moved forward. Later on, they took the matter back up again and ultimately terminated Mr. Morris. But going into this, there was clearly his intent was to figure out what was going on. And that's what discovery has elicited is that there seems to have been this animus towards Mr. Morris and others. And so what you've gotten before you is this, a number of public comment, but the public comment who it comes from is one of the letters that came last night was from Mayor McManus, who also testified today. So that's really one person who's provided two different sets of public comment. And the issue that he brought up was the one relative to that item 4FD5D that we just discussed. And so immediately upon seeing that and understanding why there may be some confusion there, that's why we went ahead and made that modification to that language based upon the comment that was raised by Mayor McManus specific to that issue. So we feel like we've addressed kind of that particular issue and that public comment for this body. The second one is from another member of the city council who was appointed by Mayor McManus and whom is a part of the entire kind of issue. What you also have before you, and you didn't hear any public comment from them today because they sent in letters. I have 5 different letters that were submitted, I believe, is what I've received as of this morning, that are all in support of and are actually members of the city, who heard that the mayor was going to be mounting this kind of opposition to this particular deal, and affirmatively sent out these letters as other members of the city talking about what had happened and what had occurred. As you can see, there's a split of kind of what's going on within the city. And it's not the purview of this particular commission to get in the middle of politics. It's to look at what happened here, look at the intent of the individual and figure out what happened and find out what's an appropriate remedy for that. And we propose that this is the appropriate remedy, given the totality of the circumstances here. Thank you, Madam Chair. We really, truly appreciate your efforts.
Thank you.
Well, and Madam Chair, this is
Yeah.
Associate Counsel Bassett, and I'd like to note, I mean, there is worked into this agreement is the confidential letter, and while that remains confidential at this time, as you know, there is under our statutes, if something were to happen to Mr. Morris were to go back into public service or go back to representing a public body, or and there were to be another ethics complaint in this arena, and we were to, that were to go forward, the commission could consider that letter when it were considering how to handle an ethics complaint in the future. So there is a bite to this in that letter and what we put in there, which will remain confidential, can be used in the future if there's a future violation. So there is bite in here that there will be things in here that will be used in the future if there is a future violation, that there will be a lasting effect if something like this happens again.
Okay. Fellow commissioners, any questions after the comments? Okay. I do see in the chat, somebody wants to make public comment, but I'm going to ask Commission Counsel Chase if that is allowable, because normally that happens at the beginning of the meeting or at the end.
Yeah, under the open meeting law, this commission takes public comment at the beginning and at the end of the meeting. Although as the chair, you do have discretion if you choose to, but if you open public comment on one agenda item, you're basically setting a process for all agenda items. So we really recommend just complying with the agenda language. And also on this particular item, I wanted to point out to the commission, part of it is whether to approve or not approve this proposed stipulation. But if it is approved, it is requested that direction be given and to authorize the chair of the commission in coordination with myself, commission counsel, to prepare and issue the related confidential letter of instruction. Now, confidential letters of instructions are very important tools of the commission because they can serve to educate on the parameters, the disclosure and abstention requirements, in this case of the ethics law. And they also serve to act as a tail for that individual to make sure that they continue to comply with the ethics law and performing their public duties. So if another case comes to the commission that would relate to a disclosure and abstention issue with this individual, at that time, we could look at that letter of caution and see if it had merit to apply it to that case. And that could be considered again in the future. So that's a very important tool of the commission. And I just wanted to point out that this agenda item has that under the authority of yourself, Chair Wallen, and with my consultation. Thank you.
Okay, all right. So we don't have to do public comment after every single agenda item. I'm going to follow those rules. So if that individual would like to make public comment at the end, when we open it back up, they are certainly offered the opportunity to do so. So at this time, fellow commissioners, I'll entertain a motion to either approve or not approve this proposed stipulation agreement.
I would move to approve the proposed stipulation agreement.
Okay, and to add to that, to authorize the chair in coordination with commission counsel to prepare and issue the related confidential letter of instruction.
I would further so move.
Okay. Do I have a second in this?
Second, Thorin Tyler.
Okay. All right. Any other comments? All right. All those in favor, say aye.
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 Okay. Opposed? Right. Motion carries. Thank you, Mr. Hardy. Thank you, Mr. Morris, and appreciate your participation and cooperation with our commission. Thank you.
Thank you, Madam Chair. Thank you, members of the commission.
Right. So everybody else, let's get everybody in. All right. Right, next item is item 7, discussion of legislative priorities and appointment of a subcommittee of the Nevada Commission on Ethics to develop the commission's bill draft request for the 2023 legislative session. I'd like to call the item and ask the executive director for his presentation.
Good morning, chair, members of the commission. Again, Executive Director Armstrong. For the record, at the last commission meeting, we had a presentation and discussion about the legislative process. And at that time, the commission had some discussion about creating a legislative subcommittee to take a look at the bill draft request possibilities for the next legislative session. And that has been placed on this agenda. I think the request was for folks to take a look at AB 65, which was passed and vetoed last year, and identify some of their priorities within that bill. I can tell you, although my time at the commission has been short so far, I think I'm hit day 60 here recently, that for me, kind of the top 3 things I found in that bill were the ability to adjust timelines for good cause, a process to formalize a settlement conference process, and the whole process of a notice of charges and confidentiality for folks. Those were really kind of my top 3. And so this matter is to formally establish that legislative subcommittee to take a look at that and prepare for the next legislative session. I would imagine that committee would hold a number of meetings, which could involve, stakeholders and getting feedback not only on the provisions that were in AB 65, but also, if there are other ethics topics out there that stakeholders and the public think, should change to strengthen and enhance our ethics law in Nevada, that this provides that opportunity with enough time to hit that September deadline to submit a formal request for a bill draft request. So that's what this item is for consideration and appointment of that committee at this time.
Madam Chair, may I ask a question?
Yes, Commissioner Oscarson.
Thank you.
Can we see-
Ross, you guys don't really want to see me. That's not part of the program here.
It is.
Ross, is it my understanding that the committee has one bill draft request, or do we have to solicit a legislator to submit the BDR for us?
Madam Chair, maybe I can assist with that question.
Certainly.
Tracy.
Sorry, Ms. Chase, I'm sorry, I should have asked the proper person. I apologize.
Oh, no worries. For the record, Tracy Chase, Commission Counsel. The process with the commission over the years has been mixed, actually. If the governor will accept it as one of his BDRs, that's our preference. However, if the governor doesn't accept it as one of his BDRs, we have solicited, another sponsor in the legislature to help us.
Okay, thank you.
Fellow commissioners, any comments, your top 3 things in the bill that you'd like to see? Or comments you want to make? Okay, all right. Then,
Madam Chair,
yes.
in
Vice
preparation,
Chair. Mhm.
thank you. In preparation for this item, I went through since I was on the last subcommittee, I went through all my notes and found one document in particular, which was a summary that we presented to the legislature. And it was actually at your request, because we had 2 different documents. One was kind of a pretty detailed one, and one was a very general summary, which summarized all the major points. And so Actually, so that was the one I was going to reference in this meeting, that, and as far as top three, there was probably about, I think there was originally like a top 50 that we had. So I think part of the exercise is going to be really to discuss each one of those and kind of narrow it down. I appreciate the executive director's comments and the three top areas that are three top items that he is interested in. But I know as we go forward with this, that we're going to present these back to the commission, and we can definitely summarize and narrow down what we really want to, what our scope is and what we really want to accomplish. And that also is with the experience of having talked to the last legislature, although a lot of those members may not be back. But having said that, I don't really have any specific top items, but I do think that the committee should really go through a fine-tooth comb with each one of these and just discuss it and make sure that, you know, we are bringing forward a bill that's not as necessarily, I mean, I wouldn't say robust, but maybe not as extensive as the one we did last time, because I think we lost many of the legislators on that. I think it was so extensive that we lost them. And I think this exercise should be really just to fine tune what we really are trying to do. And there's a lot of things in here that have changed over time that we probably don't really need to deal with. But having said all that, you know, I'm happy to be on the subcommittee again if the fellow commissioners want me to be. For my comments, thank you.
Other comments? Commission Counsel Chase, could we break the bill up? You know, maybe let the governor do part and get a legislative sponsor to do some other parts, maybe? I don't know if we could do that, because, you know, we're trying to make a lot of changes that will be good for the commission. You know, I just thoughts. I don't know if that's possible.
Thank you. You know, I've never looked at that issue, but we can be happy to get that information before the subcommittee meeting, because it is such a large bill. I agree, it becomes a little overwhelming to review all of those clauses if you're looking at it for the first time as a member of our legislature. So we definitely can look at that. I don't know the answer off the top of my head, but we can explore it. But the problem is, the more bills you have, the more opportunity for those bills to have changes to them. And some of them, as we've seen in the last legislative session, maybe at the last minute, or maybe something that we were not expecting.
Yeah, well, that's the kind of clause I was hoping that they could put in on their own. So,
Madam Chair,
yes, Commissioner Oscarson.
my experience has been that they would want to include it all in one bill. Simply because it makes it more concise. You've got the chapter open, you're doing what you need to do, and have it that way. LCB would probably be able to, Tracy, give you a really good feel for that. But I know that there were times when we asked before everything got actually submitted if some of the bills that were similar or alike were put into one kind of bill to work together, and the legislators work together to make sure if they've got the same ideas or same thoughts, that they kind of make it a little more concise. Because, and the reason that's done for more reasons than any, and you know this better than anybody, is the time constraints that there are to hear different bills. You've got 2 hearings and you've got 2 processes that you have to go through, actually multiple hearings, because you have to go through Senate and Assembly side both. So that would be my input. And I think whoever's on the committee could maybe there's some ways to streamline and tailor these things so that they're much more concise than they were. And I think we've got the right group of people to do that.
Okay.
Yeah, Madam Chair, I think Commissioner Oscarson has the wherewithal of it all. Given what he said, I don't believe LCB would allow us to split our bill, but I'll double check for sure. But that doesn't preclude somebody else from filing a bill, as we know as well, to affect the ethics law change on any matter.
Right. And I don't know if the legislature is looking into seeing how other ethics commissions handle legislators, if, you know, because that's what, you know, killed the bill by the governor, I think. So, so that's just a thought. So anyways.
Yeah, Madam Chair,
Yeah.
on that point, I
Mhm.
think that the subcommittee should probably look at that issue or at least discuss it with the governor's office and make sure that we understand fully where he was coming from, because there may be parts of that bill where the legislature did carve out themselves and add their own ethics committees, so to speak, that he may be fine with, or he or she, whoever the governor is going to be. So the committee might want to just, you know, briefly look at that and make sure that we kind of address that in our bill going forward, either address it or not address it based on our experience with finding that out.
Mhm. Good idea. Okay. Okay, so we don't have any legislative priorities at this point in time, so I'm not going to entertain a motion for our legislative priorities at this time. But our next item is to appoint members to the legislative subcommittee. Vice Chair Dufferin has indicated interest. I, of course, and I know last meeting, I thought Commissioner Oscarson had volunteered. Or does somebody want to nominate somebody else?
I'm happy to participate if that's the choice of the commission, Madam Chair.
Okay. All right, is there a motion to appoint Commissioner Oscarson, Vice Chair Dufferin, and Chair Wallen to serve on the legislative subcommittee?
I so move.
Right, is there
I
a
so
second?
move. I second.
All right, great, thank you. All those in favor, say aye.
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 Opposed? Okay, motion
Aye.
carries. Oh, that was Commissioner Greenwald, that was a delayed response, right? I thought,
Yes.
okay. All right, thank you. Next item is commissioner comments, item number 8. Are there any commissioners wanting to add any future agenda items or any comments? No? All right, well,
Madam Chair,
yes,
as one who is, as I think the newest member of the commission, and one who has asked on multiple occasions, you know, about the backlog of the cases that we have and the things that we have to do. I find it extremely gratifying to see that backlog going down, the staff working diligently, the idea to have more than one committee to review these things is, I think, has really significantly reduced backlog, and I'm grateful from that perspective that the backlog is being reduced, and want to thank at your direction and Vice Chair Dufferin's direction, the staff and the hard, diligent work that they're doing through some very difficult things. These are not easy things to handle, as we just kind of witnessed in some of the other things that we've done, and especially today with the comments and the public comment and those kind of things. And we're obligated to hear and listen and weigh those factors. So I appreciate the fact that everybody's working so hard to do that. It was a concern of mine initially, and my concerns have been abated.
thank you. Any other comments? Okay, well, I would like to add an item to our next month's agenda. I'm seeing a greater interest in the Ethics Commission and our role in keeping the public's trust in government, which is great, but there seems to be some confusion about what the public thinks our role is. Therefore, I would like to go and have a presentation next month to educate the public on what the Nevada ethics law is and isn't. We can do a social media push to get the word out and to encourage participation and to learn. And I would also like to go and invite members of the press to attend as well, to do a big outreach there, because I think that I'm seeing confusion out there as to what our role is and isn't. And I think sometimes when people don't know, then they don't think that we're doing our job, but we are. It's just, we just can't do certain things. So I'd like to see that. Okay. Other comments? All right, thank you. At this time, we will open it up again for public comment. Executive Director, are there any members of the public on Zoom that would like to make public comment?
Yes, I would like to make public comment. I'm the individual who asked if I could
Please
comment.
excuse me, please identify yourself.
Yes,
first.
I'm Judith Hoskins. I was on the city council. I would like to make a correction. Number one, I do know about the open meeting law, and I know that you can allow people to talk during your time. And thank you so much for reminding me of that. You're all doing a fantastic job. But when someone makes a false statement about me, kind of riles me. So the false statement that was made during this presentation by the attorney who knows better is that I was appointed by the mayor to be on the council. My name was drawn from a bowl. The mayor nominated me, and there were other people nominated, and my name was pulled out of a bowl. I was not nominated, or I was not appointed by the mayor. I was nominated by the mayor. I had mentioned before in my statement that I sent to you, there was a lot of mentions, and even in the presentation today, about the open meeting laws and the violations that the city had prior to me being on the council. However, there was no mention to the open meeting law violation that Peggy Levitt made, and the AG determined it was not a violation, and that was what this whole thing was about. And I found that to be concerning to me, that was not considered. Maybe you did consider it, but it should have been in your presentation, or it should have been in part of your, in that particular OAG file is 13897-354. So that determination should have been the basis, not a previous determination. And I also would like to ask if anyone reviewed the meeting, because as I put in my comments that I sent in, we record all of our meetings. And if you would just watch the recording, you certainly would find out that Attorney Morris was very aggressive in trying to get this issue through. The entire complaint, the ethics complaint, revolved around whether he knew that he was in violation by proceeding. He was the city attorney. He had to have known that if he spoke about anything concerning his contract, his city contract, that it would have been a conflict of interest. So I know you've done your best. This is 2 years. It's taken a lot of your time. I appreciate that. There's no doubt that I don't appreciate all of it. I just would like to bring up, sometimes these things go, there's no really recourse. There won't be no recourse for this because he's not city attorney anymore. So you should not have any more complaints against him as city attorney. But it's very difficult for you. I understand that. I've been in government all my life. Actually, I will be 83 years old this Friday. And yet I served on the council. I read over 1,000 pages every time we had our meeting. I researched very thoroughly everything that I did. So I'm not some stupid woman like they seem to want to make me out to believe. I'm a very dedicated individual. I believe in everyone's rights, and I believe in honesty and integrity. And I thank you all so very much for listening to me. And I'm sorry that I had to interrupt you, but when someone says something wrong about me, I'll tell you, I'm right there trying to defend myself and the city. Thank you so very much, and have a great weekend.
Thank you, Ms. Hoskins, for your comments, and happy early birthday to you. And thank you for your service.
Thank you.
Is there any other public comment? Executive Director Armstrong, have you received any additional emails?
Thank you, Chair. We received some emails of folks who testified during public comment and said they would send in their public comments. There's no additional individuals that have sent in public comment that did not participate in the meeting.
Okay, great. All right. I think that's it. So I will entertain a motion to adjourn. I guess we
Motion to
can-
adjourn, Madam Chair.
All right. Is there a second?
Second.
All right. All those in favor say aye.
Aye.
Aye. And members of the review panel, which is Commissioner Greenwald, Vice Chair Dufferin, and Commissioner Sheets, right? So you guys were scheduled for 11:30. Do you want to start earlier?
Yes.
That would be great. Can you do that, Mr. Sheets?
Yes, if we could take a 10-minute little lawyer's break, that'd be great.
Yeah, so can we commence that at 10, how about 10:45?
Okay, perfect. All right, thank you all. Have a good rest of your week. And hopefully in March, we might see each other in person. So,
Thank you all.
all right,
Thank you.
bye. Bye.